बिस्मिल्लाहिर्रहमानिर्रहीम। जीअं त अॼु असां ऑर्डर नंबर 41 पढ़ंदासीं त हीउ जेको ऑर्डर आहे इहो बि इलाही जेको आहे लॉ गेट जे हिसाब सां अहम आहे ऐं तक़रीबन हिन मां बि 2-3 MCQ 4 MCQ ईंदा रहंदा आहिनि गेट में। सो असां अपील्स फ्रॉम ओरिजिनल डिग्री जे बारे में पढ़ंदासीं ऐं सभ खां पहिरियों असां जेको आहे रूल नंबर फस्ट में ईंदासीं त हीउ जेको फस्ट रूल आहे इन में तव्हांखे जेको आहे फॉर्म ऑफ अपील वाट टू अ कंपनी मेमोरेंडम इन में हिकु ॿ चकर जेको MCQ पहिरियों आहे उहो तव्हांखे जेको आहे त नोट करणु खपे त एवरी अपील शैल बी प्रीफर्ड इन द फॉर्म ऑफ मेमोरेंडम। कहिड़े फॉर्म में अपील खे प्रीफर्ड कयो वेंदो आहे उहो अंडरलाइन तव्हां कंदव मेमोरेंडम खे त मेमोरेंडम जेको आहे उहो गेट में MCQ आयल आहे इन खे अंडरलाइन कंदव। साइन बाय द अपीलांट or his pleader and presented to the court to such an officer as it appoint in this behalf. The memorandum shall be accompanied by a copy of the decree appealed from and unless the appellate court dispenses therewith of the judgment on which it is founded. इन में असांखे हिकिड़ो जेको रूल आहे उहो असांखे मिली वियो त अपील असांखे जेको आहे कहिड़े प्रिफर्ड फॉर्म में कयो मेमोरेंडम में फॉर्म में। उन सां सेकंड आहे कंटेंट्स ऑफ मेमोरेंडम। द मेमोरेंडम इन खे मां अंडरलाइन कजो छो इहो बि MCQ सबसे पहले लॉ गेट में आया है। शल सेट अ फोर्थ कंसाइसली एंड अंडर द डिस्टेंस हेड द ग्राउंड्स ऑफ ऑब्जेक्शन टू द डिक्री अपील फ्रॉम विदाउट एनी आर्ग्यूमेंट आर नैरेटिव एंड सच अ ग्राउंड शल बी नंबर्ड कंसिक्यूटिवली। उसके बाद जो MCQs है इन में इहा शइ बि कंटेंट्स ऑफ मेमोरेंडम में तव्हांखे यादि रखणी पवंदी त द डैश शल सेट। हाणे हिकु लफ़्ज़ मिसिंग आहे ॿियो सॼी स्टेटमेंट ॾींदा त बाबा हाणे हिन मां कहिड़ी शइ जेको आहे करेक्ट थींदी। उन खां पोइ जेको आहे ग्राउंड्स विच में बी टेकन अन अपील कहिड़ा ग्राउंड्स हूंदा आहिनि अपील में जेके वरिता वेंदा आहिनि। द अपीलांट shall not accept by leave of the court urge or be heard in support of any ground of objection not set forth in the memorandum of appeal, but the appellate court in deciding the appeal shall not be confined to the grounds of objection set forth in the memorandum of appeal are taken by leave of the court under this rule, provided that the court shall not rest its decision on any other grounds unless the party who may be affected thereby has had a sufficient opportunity of contesting the case on that ground. ऐं उन खां पोइ जेको आहे असांजो rejections or amendment of memorandum. Where the memorandum of appeal is not drawn up in the manner hereinbefore prescribed, it may be rejected or be returned to the appellant for the purpose of being amended within a term to be fixed by the court, or be amended then and there. Where the court rejects any memorandum, it shall record the reasons for objections. Where a memorandum of appeal is amended, the judge or such officer he appointed in this behalf shall sign or initial the amendment. One of several plaintiffs or defendant may obtain the reversal of whole decree, where it proceed on ground common to all. So where there are more plaintiff, more defendant than one in a suit, and the decree appeal from proceed on any ground common to all the plaintiff, all the defendant, any one of the plaintiff or of the defendant may appeal from the whole decree. Thereupon the appellate court may reverse or vary the decree in favor of all the plaintiff or defendant as the case may be. Stay of proceedings and of executions. Stay by appellate court. An appeal shall not operate as a stay of proceeding under decree or order appeal from, except so far as the appellate court may order, nor shall execution of a decree be stayed by reason only of an appeal having been preferred from the decree. But the appellate court may for sufficient cause order stay of execution of such a decree. Stay by court which pass the decree. And इहो MCQs तव्हांखे यादि रखणु घुरिजे त पास द डिग्री जेको आहे उनखे अंडरलाइन कयो। इहो गेट में MCQ आयो आहे। सॼी स्टेटमेंट ॾींदा where an application is made for stay of execution and appealable decree before the expirations of the term allowed for appealing therefrom, the court which passed the decree may on sufficient cause being shewn order the execution to be stayed। MCQs कुछ जो हिन में मां तव्हांखे ॿुधायां जेके तव्हां पंहिंजे बुक्स में जेको अंडरलाइन कंदव। No order for stay of execution shall be made under sub-rule 1, sub-rule 2 unless the court making it is satisfied there the substantial loss may result to the party applying for stay of execution unless the order is made there the application has been made without unreasonable delay and that security has been given by the applicant for the due to performance of such a decree or order as may be ultimately be binding upon him. Notwithstanding anything contained in sub-rule 3, the court may make an ex parte order for stay of execution pending the hearing of the application. Security in case of order for execution of decree appealed. So where an order is made for the executions of decree from which an appeal is pending, the court which passed the decree shall on sufficient cause being shewn by the appellant require security to be taken for the restitutions of any property which may be or has been taken in executions of decree for the payment of the value of such a property and for the due performance of the decree or order of the appellate court. The appellate court may for like cause direct the court which passed the decree to take such a security. Or where an order has been made for the sale of immovable property in executions of decree, an appeal is pending from such a decree, the sale shall on the applications of judgment debtor to the court which made the order be stay on such terms as to giving security or otherwise as the court thinks fit until the appeal is disposed of. No security to be required from the government or public officer in certain cases. Exercise of powers in appeal from order made in executions or the public officer in certain cases. The powers conferred by rules 5 and 6 shall be exercisable where an appeal may or has been preferred not from the decree but from an order made in executions of such a decree, provided that where such appeal has been preferred by the judgment debtor, it shall be required unless the court is of opinion that prima facie the appeal is one which must succeed owing to an error apparent on the face of the record. In the case of decree for the payment of money, to deposit the decretal amount or to furnish the security for its payment. In the case of any other decree, to furnish security for the due performance of the decree.